Good morning, all. This hearing is in the matter CFI 057-2021 and is being held by way of video conferencing before His Excellency Justice Lord Angus Glennie, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the Registry in Dubai on the judge's instructions. The claimant is represented by Mayor Brown LLP. Lead counsel is Mr. Harris Bohr. The defendant is represented by Greenberg Tariq Limited. Lead counsel is Mr. Niels de Wolf. Thank you.
Yes, good morning.
Good morning, my lord.
Who's going to go first? Mr. Bohr.
Yes, I'm grateful. Thank you. I'm obviously for the claimant. My learned friend, Mr. de Wolf, is for the defendant. You would have seen from the skeletons that I assume you've received that there's been a great deal of agreement in relation to today's PTR.
Can I interrupt you for a moment? I received the defendant's skeleton. I couldn't find the claimant's skeleton.
Okay, well, I'm sorry about that. There isn't too much in it, indeed, and I can deal with most of those points as we go through.
Yeah.
I mean, the bottom line is, as I say, there's been a great deal of development and agreement, I should say. So what I propose to do is just take you through the points of agreement and then deal with issues where we need the court's assistance, if I may.
Yes, if that's agreeable to Mr. de Wolf, I'm sure it is.
Yes, that's
I'm
fine.
grateful. Thank you. So there is an amended defense at A2, and we have agreed to that. There's an amended reply at A5, and the defendant has agreed to that going in. There's a hearsay notice at B5, which we've accepted and we've agreed between ourselves that we were allowed to put in a witness statement in response to that, which we did last Friday. So that's agreed. There is also an application for a new witness, Mr. Lorenzo Facinelli, which we've agreed to. And we've also dealt with that statement in our response evidence filed last Friday. And there's a consent order which deals with that, in particular with the hearsay notice with the Mr. Facinelli witness statement, which is at D1 of the bundle.
I think I authorized that order yesterday.
I'm grateful. In that case, we just then move on to the trial timetable, which is also agreed, and that's at B8.
Is it a bit tight?
It's a little tight. I mean, we do have the second day is quite light. The one thing which we can add to this is that actually having looked at Mr. Facinelli's statement.
Sorry, remind me what page of the bundle it is.
It's B8.
No, page.
Oh, sorry, it's page 90.
Yeah.
So on there's a cross-examination for Mr. Facinelli, you can see on day 2. Having looked at that statement again, we don't propose to call him, in fact. So there'll be some time saving there. And then that second day, the Tuesday, is actually quite light because there's just the cross-examination of Mr. Cameron. So if in fact, for example, on day 1, cross-examination goes over, we can probably move that to day 2. And then we think that the timetable is doable, certainly, and there's some flexibility there as well.
It is an hour and a half. In closing submissions, do you anticipate it being an oral closing submission and then everything stopping, or are you going to proposing to follow it up with written submissions?
Yes. Well, my learned friend suggests written submissions. We would submit that it should be sufficient for to have oral closings, but of course we're in the court's hands. If the court thinks that that it'll be assisted by written closings, we can do that.
I'm not particularly wedded to the idea of written closings. It's just an hour and a half seemed quite short if there's quite a lot of points of UAE law.
Yes. Well, we do again. We may be able to start on the previous day. We may be able to start on the Tuesday.
Yeah, I think we should allow for the possibility that if we finish early enough on the Tuesday, we should go into written submissions with a half-hour break or something. Not into oral closing submissions to give a bit more time to make sure I understand what's going on.
Absolutely. On that point, my learned friend has suggested expert evidence on UAE law. It's actually a proposal that we made back in October. The other side weren't that interested at that point in time, but now they flag that as a possibility. And of course, we will do whatever the court requires.
I don't think it need be a matter of expert evidence, but
yes.
but if there are points of UAE law which would be better explained by a Dubai civil lawyer, a UAE lawyer, then I'd be happy to accept oral submissions from that lawyer, rather than go through the rather tedious process of swearing him in and question and answer. I'm very much in your hands, or both of you, as to how much assistance I'm going to need on questions of UAE law. And I can't tell until I hear it, and then it's too late really to ask for an extra person to explain it to me.
Understood. Well, I mean, we from our side, we do think that suggestion would be appropriate to the extent needed. I mean, we don't think there are particularly difficult points of UAE law, and we think that can be dealt with by way of submission, either through me or, as you say, through a Dubai civil lawyer.
Yes, see what Mr. De Wolf thinks on that.
Yes. Do you want to hear from Mr. De Wolf now?
Yes, Mr. De Wolf. What do you say about this question of UAE law?
Well, I think it's not. Yeah, sorry.
I just say I'm not particularly attracted to the idea of expert evidence from UAE lawyers, but I'd be happy to receive submissions from them as counsel, if you like, if that was going to be convenient. But,
it was.
As I was saying, it's up to you both to judge whether I'll need it.
Yeah, it wasn't so much an issue of us necessarily sort of applying to have expert evidence at this stage of the proceedings. That's obviously something that was explored between the parties in December 2024, beginning of 2025. We just wanted to flag it as an issue to Your Honour. There are complex issues of UAE law in respect of deceit, mistake, the time bar, and also with respect to the classification of the contract. As Your Honour knows and has previously determined in these courts, the concept of an indemnity, of course, does not exist under UAE law. So there's a real question as to how we classify that contract as an e-nominate and nominate contract. And that gives issues to complex issues of UAE law, which are best dealt with perhaps by way of an expert on civil law matters. It's not that I'm applying for that in order to that effect necessarily. I'm simply putting the suggestion out there, Your Honour, that if it would be helpful to you to have submissions on from an expert on those issues, then we're in your hands on that.
Well, the trouble is I won't know whether it would be helpful to me until it's rather too late to do anything about it.
The alternative I was going to suggest, which I think is something that's envisaged by RDC 3575, if I'm not wrong, is to have written closings, but in the form of sort of skeleton arguments on matters of UAE law. So to have it after the fact, so as not to distract the otherwise sort of agreed timetable in the proceedings, if that's something that you'd be open to.
What we could do is have a hybrid closing, in the sense that we have oral closing submissions from you and Mr. Bohr, but that by the start of that day, both sides put in brief skeletons on matters of UAE law, so that I can see what points need questioning, need asking about. And you presumably know your points of UAE law now, and could get them in really as part of your opening submissions.
Yeah, that's what we propose to do. We propose to deal with UAE law in our skeleton to the full extent.
So if you could treat the insofar as you deal with that in your opening skeletons, if you go fully into UAE law, then it shouldn't need any further explanation. The difficulty is if you combine the UAE law with a closing submission of only an hour and a half, you end up racing through it, and I'm at the end of it left not quite certain on certain points and not even sure which points I'm uncertain about.
Yes,
that's why I wondered whether then at the end of the proceedings we have written submissions focusing on the matters of UAE law, which to date haven't really been dealt with by the parties. We've had the pleadings, we've alluded to the various issues of UA law. We've had the response from the claimant on those, but we haven't really dealt with the issues.
Well, I wonder rather than that, if your opening written skeleton includes in some detail what you want to say about UAE law, then but it enables me to think of the UAE law points as I hear the evidence. It also means that at the end, you can do oral closing submissions for an hour and a half or thereabouts. And if I then think I want help on certain points of UAE law, I can then ask for it. But I would hope I wouldn't need to, because your openings would have covered it in sufficient detail.
Okay, we're fine with that. Yeah,
you're happy with that, Mr. Moore?
Yes.
You happy with that?
Yes, indeed. Yes.
All right. Thank you.
So moving then to the areas of disagreement, there are a series of applications which the defendant has made recently. Yes. You noted those. So there was the one at C5, which is a non-party disclosure application, yes, which I don't believe was ever served on us, although we do have the papers for that. That's at page 98. And on the 9th of April, there was a specific disclosure application made against us, which we haven't yet had a chance to respond to, which is at C6, page 102. Well, in relation to that, what we've said is we can put some response evidence in by this Friday. The other side haven't answered whether that's satisfactory to them. Then in addition to that, there's a new application which was served on us only very recently. I mean, I saw it for the first time late yesterday, which is an application for security for costs, which is surprisingly coming at this late hour. That's at C7. Yeah. In relation to that, there's no proposal to directions, and we say this is far too late. But we do intend to respond to some of the points that have been made in there. But we do say this is a very late application, and in fact, taking all these three together, they are a distraction, and they are going to prevent or hamper preparation for this hearing, which should be moving full steam ahead. So we're in the court's hands as to how to handle these applications. In relation to the specific disclosure and the non-party disclosure, as I say, we propose to put a response in by this Friday. And at that point, we can state whether we are happy for the court to deal with it on the papers or whether we would like a hearing. In relation to the security for cost application, we're really in the court's hands as to how to deal with that, because it is time consuming, and we say the application itself is far too late.
Why don't we deal with them now?
Well,
excuse me.
Yes. Well, on the security for cost application, we haven't had a chance. I mean, I haven't personally had a chance to even look through it. As I say, I only saw it late last night, so we haven't had yet an opportunity to respond to it. But of course, the court can look at it. I mean, we say the court ideally should dismiss it to avoid us having to spend so much time on it. In relation to specific disclosure,
when I said
yes.
Let's deal with it now, I didn't mean the security costs. I meant the disclosure applications.
Right. Well, there we haven't put in evidence in response to the specific disclosure, but of course the court can consider this. But we do note that fact. The other side have asked for it to be dealt with on the papers, and so what we've said is we will put in our response evidence by Friday, and then after that point, the court can either deal with it on the papers unless we would request a hearing.
Well, why do you? Friday is quite a long time down the road, but the hearing starts in what, 2 weeks?
Yes, less than 2 weeks. Yes.
So we really want to deal with it today, if possible.
Well, we should do, but the issue that we're facing is this disclosure application has been made late. There's no reason why it couldn't be made before.
But it wasn't, and we are where we are.
It wasn't. I mean, the point of...
If you tell me your headline points...
yes, I can. Yes,
then I can decide whether or not we need to delay it to allow you to develop them further.
Okay, this, my lord, comes from the skeleton, which I know you haven't yet received. So what we say is we hadn't had a proper opportunity to take the instructions, but we say the application's been made late and after an inordinate delay. That's point one. Point two, we say we've made clear the claimants made clear, including in the amended particulars of claim, that it will give credit for any amounts received from Mr. El Araj under his indemnity. The disclosure application seeks information about settlement agreements with Mr. El Araj, or the value of the company GSS. And they say the point goes to damages. And so our first point is we've always said in our amended particular claim that we will give credit for amounts received from Mr. El Araj. There has been some money received from Mr. El Araj, which is mentioned in the particulars of claim, but that's it in terms of the actual monetary payments. So that's the second point. The third point is that the claimants indicated in evidence, which is actually referenced in my learned friend's application, that there are no further settlement agreements entered into between the claimant and Mr. El Araj concerning Mr. El Araj's indemnity, including in relation to the DIAC proceedings, which is what the defendant wants to know all about. And we also say that the DIAC proceedings themselves, they did not involve the defendant, and they have, as the defendant recognizes, been discontinued. And then the fourth point is the actual information that they want on the value of GSS is they say they want it because it was intended to be transferred to the claimant under the terms of the D1 settlement, which is correct. There is a provision to that effect, but the word there that's important, of course, is intended. So it's not understood, we say, why the fact that it's intended for GSS to have been transferred, why that's relevant to the case, even if information about GSS, which is not our company in its entirety, even if that information were in the possession of the claimant. So for all those reasons, we say that the whole specific disclosure application is late and something of a red herring, and really isn't necessary and is a distraction, as we say, my lord.
And it goes, leave aside the lateness. It is
Yes.
late, but that doesn't, unless the lateness causes prejudice, I'm not that concerned about it at this stage. We are where we are. But the point is a simple one, isn't it? They want documents showing what you've received from the other defendant, former defendant, by way of settlement or otherwise.
Well, they
want to know the value of value that you've obtained from him.
That's right, but it goes further than that, because they're not asking for proof of the amount that we've received. I can't remember exactly, but we have received some small amounts in cash before the settlement agreement was breached by Mr. El Araj. But what they want is a valuation of the entire company, GSS, which hasn't been transferred. There was a provision within the settlement agreement between us and Mr. El Araj for GSS. That was the intention. Yeah. That was never carried out, and yet they want information about that. They've written to the accountants. This is a third-party disclosure application that they've also made for that information. But that's an intended transfer. So how that helps them, we don't understand.
Your case is intended and wasn't carried out. I don't know whether that's accepted.
I don't know either, but they do use the word intended. And my instructions are it hasn't been carried out, and the instructions also are there is no further settlement other than the one that they know about, under which some money was paid, and they know the amount in relation to that, and that's it.
Mr. DeWitt, what do you say about this?
Yeah, I was going to say a few words about that. I think from our learned friend's skeleton, I think there are three issues that he takes, which I've just heard now as well. First is the issue of delay. The second is the extent of the requests, which are referred to as extensive. And the third point is the relevance of the requests, the documents that are being sought. Just on the delay point, the application was made on the 9th of April. And it was made at that time because it relates to issues which arose out of the Mr. ALMHEIRI's witness statement, which was served on the 24th of January. So once that witness statement was served, it's at paragraph 93 of that witness statement, an issue came to light with respect to the DIAC proceedings, the fact that they had been discontinued in July of 2024. So that gave rise to the request that was first made on the 5th of March to begin with. In response to the questions that were then asked about the DIAC proceedings, my client received a very, we would say, evasive and cryptic response. That was on the 14th of March. We then sent a further letter on the 18th of March, and no response was forthcoming to that request. So it's not a series of new requests that are now being made on the 9th of April. It's an application that relates to events which started, we say, on the 24th of January, by virtue of what Mr. ALMHEIRI said at paragraph 93 of his witness statement, which resulted in a letter request made on the 5th of March, a response from the other side on the 14th of March, and a further letter that was sent by us on the 18th of March, to which no response was received. And in light of that lack of response, and in light of the evasive and cryptic response received to the earlier letter on the 5th of March, that's when the application was made. So that explains the timing of the application. I don't know if there are any questions with respect to delay at this stage, Your Honour.
Well, your timing means you left it a fairly non-urgent basis until 2 weeks before the hearing. But be that as it may, I don't think this is going to be decided on the question of delay and timing. I want to know more importantly what you say about the relevance and the extent of your request.
Okay, thank you. They're not extensive requests. I think they really boil down to two categories. One is documents.
Are we talking about the non-party disclosure or the inter-parties disclosure?
The non-party is basically the category B documents of the specific disclosure application. So if we deal with the specific disclosure application first, the same issues will manifest in the non-party application. Okay. So there's basically two broad categories of documents. The first is documents in relation to the DIAC proceedings. That's proceedings which were commenced by the claimant against the first defendant, Mr. Ezelldine Araj, in connection with the settlement that the two entered into. Those proceedings were commenced in, I believe, September 2022, and then discontinued for unexplained reasons in July 2024. That's sort of the first category of request, the DIAC proceeding documents. The second category of request is in relation to, we call them GSS documents, looking at the value of the GSS assets. So that we don't say that's extensive. Those are documents.
And the value of the GSS assets is relevant in what way?
The value of GSS assets is relevant to the quantum, to the duty to mitigate. So the duty on Mr. ALMHEIRI to mitigate his losses, in other words, to actively pursue the claim, we say, against Mr. Araj, and the consequence and quantification attached to a breach of that duty, which we say is the simple but-for analysis. Had he pursued the claim diligently, he would have recovered the GSS assets and been recovered the 22 million dirhams, which is why the value of GSS is relevant, not in terms of looking at actual recoveries, but in looking at the potential recovery that Mr. ALMHEIRI could have made had he complied with his duty to mitigate.
I see.
So it's relevant to put a figure to that breach. That's why we say the GSS value is relevant. And then with respect to the DIAC proceeding documents, they're relevant in three respects. First is there's some overlap with the GSS value, because the claimant in the DIAC proceedings may well have ascribed a value to the GSS assets. So he may have sought, we don't know at this stage, but he may have sought specific performance, so a transfer of GSS assets. But he may well have said in the alternative that in lieu of a transfer, I would like damages of a certain amount. So there may be an indication of value given in the prayer for relief in those proceedings. So that's one aspect of why those DIAC proceeding documents are relevant. That's copies of the pleadings. The DIAC proceeding documents are also relevant because Mr. ALMHEIRI has said things in these proceedings, and you have the DIAC proceedings, which arise out of a similar set of circumstances, where he may well have said something else. So it's relevant to know what he said in one set of proceedings and what he said in other sets of proceedings in relation to the same subject matter. It obviously affects his credibility. The final point is it's relevant, again, to the duty to mitigate, to understand exactly why Mr. ALMHEIRI discontinued the DIAC proceedings in July 2024. No explanation has been provided. We have asked for an explanation. We haven't been given one. And it's very peculiar that Mr. ALMHEIRI commences DIAC proceedings, trying to recover substantial amounts from Ezelldine, and then all of a sudden decides to discontinue them without any explanation.
Right.
So that's really why we're seeking the documents.
What sort of bulk of documents? What sort of quantities are we talking about, do you think?
Well, it's copies of the pleadings in the DIAC proceedings.
Yeah.
Which should be readily available to Mr. ALMHEIRI. There's no reason he shouldn't have them readily at hand. Documents exchanged with the DIAC Center. Obviously, something may have been said in the context of those communications about why the proceedings were discontinued. It may not be a formal settlement. It may have been some sort of agreement, other sort of agreement between Mr. ALMHEIRI, Mr. Ezelldine. We just don't know why those proceedings were discontinued. Copies of settlement agreements, I understand there are none. To the extent there aren't, it shouldn't be very difficult for Mr. ALMHEIRI to confirm that in a witness statement. And then the GSS audited financial statements, again, if Mr. ALMHEIRI has them, no reason not to provide them to us. It's a very defined category of documents.
Yeah.
And that's really it.
And the non-party disclosure, you're seeking the GSS financial documents.
Yeah, for the non-party, that is an application that was made against GSS and GSS auditors Deloitte and Touche. That is for the financial statements of GSS and copies of any insurance policies relating to the assets held by GSS, because those insurance policies will have ascribed a value to those assets. So there will be an insured value, which again will give an indication of the value of those assets to the extent that the financial statements don't.
And GSS haven't responded.
GSS haven't responded. That's a company that's controlled by Mr. Araj, so perhaps not surprising. Their auditors have, Deloitte and Touche. They have simply indicated in correspondence that they would require a court order, but they haven't given any indication that they would object. And they haven't so far responded or participated in the application.
Their approach is the proper approach, basically saying we will comply with a court order, but we can't volunteer stuff.
Yes.
Yeah.
Which was to be expected, frankly.
Yes. Mr. Bohr,
yes.
Is there any? Are we not making a bit of a mountain out of molehill here?
No, my lord, I don't think we are. I mean, the mitigation point is not one that I've heard previously. I'm not even sure it's pleaded, and I've been told by my Dubai solicitor is that there's no duty to mitigate under UAE law. In fact, if one looks at the disclosure, we've been told it's not extensive, but it's at pages 103, 104. There's 7 categories of documents, which are, and each of them are fairly large. These are not, if it's a case of mitigation, which we say isn't in fact one open to the other side to take in any event, there's absolutely no reason why that couldn't be, this disclosure couldn't be a resort in the course of disclosure. Plus, what you hear from Mr. De Wolf is a lot of the time he was using words like maybe, this may have happened, this may be contradictory evidence in the DIAC proceedings, which are confidential proceedings, of course. It's pure speculation. And what in fact is being done here is the defendant is wanting to make the claimant do lots of work before the 2 weeks before the hearing. Once those documents have been given over, one can rest assured that what the defendants are going to then start doing is probing and asking for more, and essentially distracting from the proper preparation for this trial. So it is extensive, it is prejudicial, it doesn't go to any point.
Mr. Bohr, can we not break it up a bit? The pleadings can't be that difficult to obtain.
The pleadings may not be difficult to obtain, but then there's a question to the extent that the other side are entitled to those. These are proceedings in relation to Mr. Araj. The defendant is not a party to those proceedings, so there's an issue there.
But they're proceedings in which you're trying to recover from Mr. Araj sums which are relevant to the quantum of the claim against the second defendant,
which we were attempting, because those proceedings are no longer on foot. I mean,
so surely he's allowed to see what came of it and what your attempts were and whether they were reasonable.
Well, I'm not sure that's the case, my lord, because in a sense, if there's no mitigation issue, and that's not being pleaded, and that isn't permitted under UAE law, we wouldn't understand on what basis that they could get that information. They certainly, as we say, certainly we would want to give credit, or would have to give credit, for amounts received from Mr. Araj, but that's already been confirmed. I mean, my lord, I do have a suggestion which may short circuit much of this, and that is, we could provide a witness statement confirming that there has been no further settlement and confirming exactly the amounts that have been received from Mr. Araj. That we submit should do the trick at this stage.
Well, that assumes that it's accepted that there's no mitigation in UAE law. I don't know that is accepted necessarily.
Or that it's not. I just don't record it being pleaded, even the mitigation point. And it's, as I say, it's the first time that I've heard that that's the reason for this disclosure application. My understanding from the papers was that it had to do with damages, but now we're being told it has to do with mitigation. I mean, it's again, it's difficult.
Two sides of the same coin, aren't they?
Well, not quite, my lord, because if mitigation isn't something that's acceptable under or pleadable under a UAE law, then it would be different. And in terms of an indemnity, in any event, one can choose which of the indemnifiers one can pursue. One doesn't have a duty to pursue all people who offer indemnities, and it's a matter of general principle. We didn't need to pursue Mr. Araj. We could have just pursued Mr. Cameron and left it to Mr. Cameron and Mr. Araj to deal between themselves with the issue. So, I mean, that's the normal course. We didn't have to pursue Mr. Araj at all. The fact is we did, and we've recovered something, but at this point in time, certainly far from everything. And what we're proposing, again, just to be clear, is a witness statement just confirming what we've received. And again, confirming that we would give credit for amounts that have been received, which is, of course, what goes. This goes to the heart of the question of justice and fairness, and double recovery, which, of course, we can't have.
Mr. De Wolf, you're going to say that's not good enough because do you accept the proposition that under UAE law you can't have arguments about mitigation?
No, we don't. That's a point that we will be arguing. It goes to loss. It's ultimately a question of loss.
Have you pleaded anything about mitigation in your pleadings?
I think from memory, there was a pleading in relation to loss and causation in there. So there's no specific provision of the UAE Civil Code relating to the duty to mitigate, but it's reflected in a combination of the duty of good faith and the duty not to cause your own loss, and that's how it's reflected in the pleading.
Yes, I see. Well, Mr. Bohr, I'm minded to grant this application. If you want to talk about the details of it and whether certain bits could be cut out just because we're so late, but I imagine the fact is all the pleadings will be together somewhere. And it'd be remarkable if they had been dispersed, and ditto with the financial information.
Yes, I mean I can't answer that, but it's a matter of proposition. I imagine if the pleadings, if there have been full pleadings, they would be together. But I don't have any information.
Well, I'm proposing then to make an order in terms of the. This is the specific disclosure application, which is number 14, I think, CFI 057/2021/14. If that order is made, does it remove the need for the non-party disclosure application?
So yeah, it might. To the extent that Mr. ALMHEIRI has copies of the GSS financial statements. If he doesn't, then obviously we would still maintain the application that's been made against GSS and Deloitte.
Mr. Bohr, are you going to say anything about the non-party disclosure application, or it's really not strictly something you're technically involved in?
Yes, it's not something that we're involved in. I mean, to the extent there's overlap, then clearly one or the other wouldn't be needed, but I can't say more than that.
I think I'm going to grant the non-party disclosure application, which is CFI 057/2021/13. What I would say is this: granting these applications does not necessarily mean that they will be admitted at the trial. It depends on what impact they have. I don't think it would be right at this stage to make an order which has the practical effect of disrupting the trial date. So it doesn't follow, Mr. De Wolf, that you can get all these documents, put them in, and reshape the whole narrative of the defence. That is open for argument. I'm not ruling either way on that. It shouldn't be assumed that you put in a further 1,000 pages, supplementary witness statements and all that, and really
Understood.
Change the nature of the case.
Understood.
As the same goes for you, Mr. Bohr, that
yes,
when you see what use is sought to be made of them, it is of course open to your clients to take whatever view is appropriate and make any application that's appropriate.
Yes. My Lord, can we just check the actual specifics? I just, if I may, just go through each of the categories at page 103 and 104. So the copy of the pleadings, we've heard what,
this
what
is one
said.
What page?
This is 103.
Yep.
So a copy of the pleadings, I heard what the court said about that, and witness statements and expert reports. Those are all things that have been filed. The fourth category, copies of documents exchanged between Mr. ALMHEIRI and Mr. Araj, concerning purported discontinuation, dismissal, termination, and withdrawal. I mean, that is a broad category, and not one, again, which we say goes to any of the points, even points of mitigation.
Well, if the lawyers are agreeing some resolution, that goes precisely to that point, doesn't it?
Well, if they're in terms of discontinuation,
dismissal, termination, or withdrawal, those are all
yes,
ways of terminating those proceedings.
But the issue of mitigation surely would be the amount that's been recovered, whether that's whether or not that's reasonable or not satisfactory. The actual discontinuation themselves, we would submit, is not relevant one way or the other. And if
the terms on which the discontinuation happened might well be relevant to an argument on damages and mitigation.
Okay, my lord.
Sorry, I cut across you. But
no. I mean, I can see that could be in theory the point, but I mean the point that I made is that surely the issue would be the actual settlement itself and the terms of the settlement. Yeah. But I see that the two are connected.
I think the two are connected. Yes. And there would be time for these sort of distinctions if this had happened 6 months ago, and I don't criticize you for that. But I think doing the best I can to deal with the points, I'll allow that. Was there anything about E, F, and G? I think E is covered by what we've discussed already. F and G are the GSS financial statements and so on.
And insurance policies, again, just thinking on the spot, that I guess goes to valuation, I assume.
Yes, it does.
And your point would be that, just to clarify, that on a mitigation point would be a failure to get hold of GSS?
Yes, it would be a failure to act with due diligence to effectively affect a transfer of GSS.
Right.
And then obviously obtain the 22 million dirhams under the settlement agreement. So a failure to take action, act with due diligence. And so I was just going to add, with the insurance policy would presumably have some sort of insured value that is ascribed to those assets, so that would give an indication of value.
Well, I don't have anything further to say on the actual policy, given the court's order. As safe to say, of course, we do reserve a position in relation to the actual points that have been made, and we don't take it that the court's stopping us making legal points, of course. So on that basis, my lord, I don't have much more to say on this.
And it might be, for example, with the insurance policies, if all is being looked for as an insured value, then you can discuss with Mr. De Wolf, and if you can just extract a page or two, that might be enough.
Yes. Yes.
I'd hope, though, that sort of detail can be resolved between you without the need to come to the court.
Mm-hmm. Okay,
right, so I'll grant those two applications. What next, Mr. Ball? Back to you.
I don't have anything else on my list, actually, my lord. So I turn over to my learned friend.
Yes, Mr. De Wolf.
Yeah, there's only the issue of the security for cost application, which was filed late last night and then served this morning and added to the bundle. I don't know if Your Honour has had a chance to look at that. Presumably not. And I expect the very first question will be, well, why is this being brought so late in the day?
Yes.
So if I could just address you on that and then just outline the grounds. I don't expect to walk away with an order today. I appreciate my learned friend hasn't had the opportunity to look at it, but perhaps we could get some direction from the court as to what happens next with that application.
Yep.
So just on delay, three reasons really why the application was brought so late. The first reason is that we only found out in March of this year that Mr. ALMHEIRI transferred the company which was supposed to receive the GSS and GSS assets under the settlement to a Manil Nejar, who is an associate of Mr. Araj, back in January 2024. So the transfer happened in 2024. What seems to have happened is that Mr. ALMHEIRI has divested himself of assets and potential receivables, transferred them out to a third party in January 2024, just before a judgment was to be issued in respect of proceedings in which he's named as a defendant. They're known as the market proceedings. That judgment was issued in February of 2024, so just a month later. And then what happens after that is you have a payment, or supposedly a payment, that's made to QNB in May 2024, and then a discontinuation of DIAC proceedings in July of 2024. So a very sort of close succession of events that have not been explained, that have no clear rationale, and the only natural inference from our perspective, absent any explanation with respect to those events and actions that Mr. ALMHEIRI took, is that there appears to have been some steps taken by Mr. ALMHEIRI to make himself judgment-proof. That's the first point, really.
When do you say you discovered this?
In March 2025, that's in the reply witness statement of Mr. ALMHEIRI. I think it was 7th of March when that statement was served, where he basically explains that he transferred, the company's called EVL, which was supposed to receive the GSS assets, to Manil Nejar in January 2024. So a transfer that happened a year before, he only sort of discloses that fact a year later.
Right.
And doesn't explain why he did it, whether he did it for value, any of that sort, what agreement he may have struck with Mr. Araj in relation to that transfer. Because to our knowledge and to our client's knowledge, Mr. Manil Nejar is an associate of Mr. Araj, not an associate of Mr. ALMHEIRI. That's the first point. And obviously, Mr. ALMHEIRI hasn't given evidence on that. We've asked the questions, we haven't received a response. But I do acknowledge that those requests were made late on Friday. So Mr. ALMHEIRI and his team wouldn't have had the opportunity really to consider those. The second point is that the issue of security for costs was explored before. There was correspondence exchanged with opposing counsel back in December of 2024 and earlier this year. And in response to concerns that our clients raised, we were told that the Marca judgment, so the finding of liability against Mr. ALMHEIRI that was made in September, had been quote unquote reversed. We then found out in February of 2025, specifically the 15th of February 2025, that the case had in fact been remanded back to the Dubai Court of Appeal for reconsideration, not necessarily reversed, but remanded.
Yeah.
And there's a judgment expected from the Court of Appeal later today. And the third and final point with respect to delay is that based on what Mr. ALMHEIRI has said in his own evidence and what his legal team have said, is that he has apparently made payments of more than 32 million dirhams over the period of less than a year. So any order for security for costs against him would not appear to be prejudicial to him or burdensome, given the substantial payments he's allegedly made. So those are just the 3 points on delay, just to explain why the application is being made now. It wasn't made before. I don't know if you want to hear me now just on an outline of the grounds on what basis the application is being made, or if you would prefer simply to read the application in your own time.
Well, tell me in brief detail.
I'll keep it very brief. It's basically an application on the basis of non-enforcement. So RDC 25.1026. So on the basis that Mr. ALMHEIRI has taken steps to effectively make himself judgment-proof. The first sort of indication is, in the course of the markup proceedings, various creditors in the court conducted searches and pulled together a list of Mr. ALMHEIRI's assets, and it appears he has very limited assets. Now contrast that with the payments he says he has made of more than 32 million dirhams. That doesn't add up. So the natural inference to draw there is he doesn't have the assets in his own name. He's transferred them out to be held on his behalf by others. And that's consistent with the second point, which is that initially, going back to the whole QNB loan restructuring, Mr. ALMHEIRI issued checks in his personal name out of his personal accounts. And then later on, he issued checks, he issued manager's checks. So manager's checks basically allows you to hide or mask the source of funds, because you get the bank to issue a check for you and you don't know where the money is coming from. So he's been doing that repeatedly with respect to payments to QNB, masking his source of funds. And what he's also been doing is issuing checks from third-party companies. And having conducted investigations in relation to those companies were set up very, very shortly before the first Marker ruling came out in October 2021, holding him and others liable to pay some 450 odd million dirhams to Marker's creditors. And two, they are companies ultimately owned by his brother. So again, very suspicious, peculiar circumstances. And the third basis is the recent transfer of the company that was supposed to receive the GSS assets that was effected in January of 2024, shortly before the Marker decision, Court of Appeal decision in February of 2024, which he only disclosed to us in March of this year. So those are the three sort of grounds we rely on in terms of giving an indication that Mr. ALMHEIRI is actively taking steps to make himself judgment-proof in an attempt to evade payment of any judgment debt.
Yeah. Yes, Mr. Bohr.
Well, there's not much I can say, my lord. As I say, I only saw the application yesterday. But what I do understand from my solicitors is that we proposed to go back on some of the disclosure points that have been made. There's been points of information that have been mentioned just now, I believe on Wednesday, so tomorrow. And then also, I think, to respond to points raised in the application by Friday. So we are cooperating with the requests and the application itself, but I can't talk to the actual issues themselves. Because, as I say, I'm not familiar with them at all, and I don't have any instructions whatsoever on them. But we have made sensible proposals to deal with this. I mean, as a practical matter, I mean, we are less than 2 weeks away from trial, so I'm not sure exactly how this would work and what costs indeed haven't yet been incurred, which are to be incurred. I mean, brief fees, for example, presumably may have already been incurred. But this is for further down the line.
I meant to ask Mr. de Wolf, the application is in respect of future costs or costs you've already incurred?
Both incurred and anticipated. There is a cost schedule that forms part of the exhibit.
Right. Sorry, Mr. Bohr.
Yes, and I don't have much more to say, my lord, apart from the fact that we are dealing with the questions that have been raised. And we proposed 2 dates, I think Wednesday for giving some disclosure, I think Friday for responding to some of the questions that have been asked. And only at that point would I really be in a position to make submissions.
Right. And do you want an oral hearing to deal with it, or do you want to deal with it in writing?
Again, I'm not in a position to know the full extent of each of the issues at this point in time. But if we have permission to state that when we put in our evidence on Friday, that would be helpful. I don't know whether that's going to be acceptable to the court. In other words, when we put in our evidence, whether we state whether we're happy for the matters to be dealt with on the papers, or whether to have an oral hearing. I mean, we certainly see the benefit of having it done on the papers, given the short time to trial. But I can't say now whether that's something that's appropriate, because I don't have a full grasp of the extent of the issues yet.
Okay. I'm just thinking about how it works timing-wise. If you get your response in by Friday sometime, it means that any order, if I did make an order for security, it would be only a week before the hearing.
Yes.
So I suppose any evidence you put in or any response you put in would include comments about timing.
Yes.
Yes, very well. But I obviously can't deal with it at the moment, which is unfortunate. I think the best thing is if Mr. Borg can give a response by close of business Friday. Let's close of business UAE time Friday, and unless I'll deal with it on paper, unless there are good grounds put forward why I shouldn't do that.
Yes.
If there are grounds put forward as to why an oral hearing is necessary, we'll try and convene one for the probably for the Tuesday.
Yes.
Which is just short of a week before the hearing starts.
Yes.
So if you can both be available for a hearing on Tuesday, I'd hope we could deal with it on paper, but that depends.
Yes, and we note that indication. I'm grateful. Thank you.
So with the security for cost matter, we'll simply, for the moment, make an order that is adjourned and to be dealt with either in writing or orally, depending on what seems appropriate at the time.
Yes.
Right. Is there anything else that needs to be dealt with today?
Not from my side, my lord.
Mr. De Wolf?
Just a final matter, perhaps it's already been agreed, but in terms of the format of a hearing, I'm assuming that's going to be a remote hearing.
Yes.
Okay. Nothing else for me then.
I don't think there's anything else on your list that... I suppose the trial timetable may need adjusting, and if the material to be disclosed throws up more issues, may require longer. And we have, in theory, 5 days available, but there's no point using them unless we need them. But we shouldn't ignore them if we do need them. Very well. We'll proceed on that basis, but otherwise the order will be made by the registry in the usual course. Thank you both very much.
Thank you.
Thank you very much.